Hello, everyone. My name is Bradley Jackson with the Tennessee Chamber of Commerce and Industry. I want to thank you all for taking time to join us today to have a discussion about the PRO Act. Inevitably, we've heard a lot about the PRO Act, so there's a lot going on. We appreciate Wimberly Lawson, who's going to give us an update today. Susie and Carolyn, our events team, will be managing the meeting. I believe there'll be opportunities to place questions in the chat box or different things that come up over it. The PRO Act is otherwise known as Protecting the Right to Organize Act. It was introduced in 2019, and it makes a number of very significant changes, if enacted, to the National Labor Relations Act. It is strongly supported by organized labor through, especially in Congress. Congress has already advanced it. It has, we believe, a significant impacts on employers. So we wanted to make sure you all know about this and can be prepared. There's a lot of opposition from this, especially from business groups in the U.S. Congress. U.S. Chamber, National Association of Manufacturers, a number of groups have outright opposed the initiative. It gets into independent contractors, unfair labor practices, union election, employment agreements, and other litigation and civil actions. So we'll take kind of a deep dive on it today. I'm going to now introduce our speakers. Fred Bissinger. Fred, as I mentioned, is with Wimberly Lawson. He is a tremendous resource for the Tennessee Chamber as we review various legislative proposals. Often I will give Fred a call and kind of ask him, what something does, and he's always on point. Specifically, his primary areas of practice are employment discrimination defense, ADA and FMLA compliance, wrongful termination defense, and general liability legislation. He is here in Nashville, and one note about Fred, he is a former United States Navy Judge Advocate General, which I thought was interesting. So congratulations to you, Fred. Thank you for your service. In addition, he has a substantial presence with SHRM. The Chamber works to partner with SHRM on a number of initiatives. He's headed up their legislative committee, so he brings powerful insight to this today. Joining Fred will be Howard Jackson, and Howard is out of Knoxville with Wimberly Lawson. Primarily, Howard focuses on labor and employment law, employment litigation, religious discrimination, and business and commercial litigation. So, and both are tremendous resources for the business community. So with that said, Fred, Howard, I will turn it over to you all.
Well, thank you very much, and we appreciate the opportunity to be of service to the Chamber. Guys, good to be with you this afternoon. I wanted to kick this off with just a couple of introductory comments. If you look at, statistically speaking, the percentage of workplaces in the private sector that are unionized over time, if I have my numbers right, sometime in the 70s, we hit a high water mark of about 33%, something in that general vicinity. And over the last, at least roughly close to 10 years, the number in the private sector has been, somewhere in the vicinity of 7%. So there has been a steady erosion of unionization in the private sector over the last number of decades. Now, the public sector is a very different scenario because many public sector workplaces are organized, but that's different than private sector. So, and if you look at that downward trend over the last number of decades, that corresponds with both Republican and Democratic administrations. It seems like the administration in place has not necessarily been a big factor in moving that needle in terms of increasing union organizing and unionized workplaces in the private sector. All that being said, President Biden has made it abundantly clear for any of you who followed the campaign both before he became the presidential nominee and after, during his campaign against former President Trump, and now that he's in office, President Biden has been hammering on this notion that unionized workforces make America stronger economically and help workers. that's a philosophical debate that is definitely, the jury is out on the allegations that he's making, or the representations that he's making, that unionized workforces actually in today's economy help businesses, help employers. And really that the way that it's set up with the National Labor Relations Act is that it is supposed to be a contentious relationship between employees and business. And for those of you who live and run businesses, are responsible for businesses and the employees, having a contentious relationship with your employee base, as you know, is not necessarily the healthiest and most effective way to run a business and to be competitive in today's hyper competitive global market that we are all competing in one way or the other. So there's that's sort of a big picture backdrop to where we are and what are sort of the issues that we're grappling with. Another point I wanted to make, though, is that for those of you in the Southeast, that the Southeastern states have generally been very resistant to union organizing campaigns. Most union organizing campaigns in private sector employment do not fare well here in the South. Howard, more than I, but Howard and I together, have clients that are organized by the UAW. So we've done, the union organizing, the collective bargaining negotiations with the UAW, and other unions as well. And it's different here than it is in the Northeast and the Midwest, where unions are simply entrenched in many places as a way of life. The question is really in today's economy, how can a company that's unionized be competitive, and does that really bring value to the employees and the company as a whole? That's a larger philosophical question. But I wanted to bring one example to you of where this gets really, really interesting, given the insanely political, hyper political world we live in. For those of you who are following the unionizing activity at Amazon's Bessemer, Alabama plant, that has created all kinds of interesting issues and tides that are sort of contrarian. For example, you have staunchly conservative Republican senators like Marco Rubio, who are siding with the union, hoping that the union organizing effort prevails and that Amazon's Bessemer, Alabama plant is unionized. And his explanation for it is that basically, Jeff Bezos has supported far left political figures and ideologies over the past years. And, if that's his political philosophy, he ought not to complain about it when those chickens come home to roost, as they say in the South, and that his business in Bessemer, Alabama is organized. And if it's organized in Bessemer, Alabama, what does that mean for, his operations here in Nashville and elsewhere around the country? So in the past, you would never have somebody, a conservative Republican senator like Marco Rubio, supporting a union organizing campaign effort. But yet today, that's where we are. So, I mean, the tides are, it's like a rip tide in some respects, that we just don't know how things are going to shake out. We do know in our review of this PRO Act, at least as the way it's written, is that this brings fundamental change to the landscape of the National Labor Relations Act and how it's implemented across unionized work facilities. And more importantly, so you understand that the National Labor Relations Act likewise applies to non-unionized workplaces, because employees at non-unionized workplaces have rights. For example, their Section 7 rights to engage in protected concerted activity, essentially dealing with issues that touch on wages, hours, and working conditions. And you may remember from the Obama administration, NLRB, there was a concerted push to address issues like handbook policies in non-unionized work environments that the NLRB felt somehow handcuffed the exercise of Section 7 rights, despite the fact that the behavior that companies were trying to limit and eliminate from their workplace were clearly in violation of their behavioral policies, their discrimination policies, their harassment policies. There was the one case that was before the NLRB in which a company fired an employee who, if I recall the facts correctly, was on social media with some coworkers and referred to his supervisor as a effing a-hole, but he used the full phrase, and the company fired him based on that behavior. And the NLRB was very unhappy with that and litigated with that company over the issue. Because they claimed that was protected concerted activity under Section 7. The Trump administration and NLRB walked that back, saying, a company has a right to discipline and terminate people who behave like that, because that behavior is simply unacceptable on multiple levels, and that is beyond the scope of Section 7. But this balance as to what is protected concerted activity at both unionized and non-unionized workplaces is going to be a huge issue with social media and social media behavior that makes life very complicated for what is and isn't potentially protected behavior, et cetera. But there's a host of other issues that are totally game changing, new and different, that don't exist under the NLRA that are proposed in the PRO Act. So Howard and I are going to, at a warp speed and at a 10,000 foot level, touch on these main issues, because there's far more than we can cover in an hour. But we want you to have a general understanding of what you're going to be contending with, so you can make informed decisions as to whether or not you think that supporting the PRO Act is a good thing or not, and or what is your company philosophy going to be on dealing with unionizing organizing activities and unions in general. These are big philosophical issues that I leave to your ultimate discretion. So Howard, with that being said, to me, there are sort of four primary categories of changes that we are going to be talking about today. The first are the elections, second's bargaining, third enforcement, and then fourth some other takeaways. So why don't you let's give the audience a 10,000 foot level discussion about these four categories, and then we're going to break them down.
Sure. One thing to realize right off the bat, and what we're talking about here, there's been a number of things in the news in past years, in the past two administrations, about how the National Labor Relations Board itself was swinging the pendulum on various rules, either through case law or through regulations they would implement. Well, this act is not relying on case law. This is not regulations. This has been proposed and has passed the House. It's now in the Senate to change the statute itself in huge ways. And as Fred mentioned, we can kind of break it down into some categories. One of the first things we want to talk about is elections. Since the National Labor Relations Act passed, the National Labor Relations Board has conducted elections at workforces to determine if the employees want to have a union present or not. An employer can also voluntarily recognize a union based on a card check. Doesn't happen very often for obvious reasons. And so elections have been kind of one of the big focuses of the law and of what the labor board does and of how they conduct them. And so there are lots of things that go on in an election. For example, who's eligible to vote? Who's going to be in the bargaining unit? Who's not going to be in the bargaining unit? What are the rules of the road for both employers and unions in terms of what they can do and what they cannot do in elections? And this law changes those things in significant ways, as we're going to talk about in just a minute. And so the overall push of it is to make it easier for the union or a union to get into the workplace and to prevail in an election, and harder for the employer to fight in the election, handcuffing the employer in ways that have not been done before, have not even been proposed before. And so this is one of the ways that this administration wants to push to give a leg up, if you will, to the unions. The next sort of major category is bargaining. If a union prevails and comes in, then and they're certified as a representative, then the employer has an obligation to bargain with the union over wages, hours, and working conditions. The most common thing that you think about there, you're going to try to bargain toward getting what's called a collective bargaining agreement, a contract between the company and the union that sets out, work rules, pay, benefits, all manner of things that can be addressed in such an agreement. And for as long as this law has been around, there has never been any kind of mechanism to enforce an agreement on either party. The whole idea was that the parties will get together, they'll bargain. There's an obligation to bargain in good faith on both sides. And if either side engaged in behaviors that demonstrated they were not bargaining in good faith, you could go to the labor board and file a charge. They would, investigate. There'd be remedies that they could put into place. But fundamentally, it was up to both sides you can want to bargain hard, you want to strike, you want to have a lockout. What are the things that you're going to do to influence each other? And at the end of the day, the cookies fell where the cookies fell. We're going to see that's not going to be true if this law passes. Of course, the law always has types of enforcement, and under this law, from the beginning until now, the kinds of damages that an employee could receive. For example, if there's an allegation that they were discharged because of their union activity, okay, well, that would violate the law. We can all understand that. There would be a charge at the National Labor Relations Board. They would investigate. If the regional director at the labor board decided that there was merit to the claim, they would bring a complaint, and this would go through a hearing before an administrative law judge. And the employee could receive their lost wages and compensation, going back for a few years and potentially going forward. But they also had an obligation to mitigate their damages by getting another job. And so you would sort of figure it out in a way that if the employee had a meritorious case, they would ultimately be able to get the damage award that would financially place them in about the position that they would have been in had they not been discriminated against. Well, you're going to see in this law, there's a whole bunch of changes that give employees more remedies, stronger remedies, harsher remedies, fines against the employers if they don't comply with certain things, and even give employees a way to get out of the administrative process where the claim is heard by a law judge and get into court and have a jury trial. So we'll go through it, but it's much, much, much harsher towards employers than the previous law. Then I say other takeaways. We'll see what some of those things are. They have to do with rules like joint employment and things that an employer can do, cannot do with their workforce. And it's all sort of designed to tie your hands more so and to restrict your ability to deal with your workforce far more so than in the past. So let's go ahead and get into the elections piece.
Yeah, Howard, you're going to jump to this next slide, I believe, slide number 4. And for the audience, this is dealing with the issue of independent contractors. Independent contractors and joint employment are huge pushes for the Biden administration, not just within the context of the National Labor Relations Act, but across the board at the EEOC, Department of Labor, Wage and Hour Division, et cetera. So what Howard's going to explain to you here is of critical significance in the context of the National Labor Relations Act, but it's the import of this exceeds far beyond the NLRA. So go ahead, Howard.
Well, it sure does. Because the same kind of proposal is in other areas of the law through this administration. And why I put this under elections is one of the questions you have to answer in an election is who gets to vote? And the people that get to vote are employees. If you're an independent contractor, you don't get to vote and you don't have a right to organize. But if you're an employee, you can. And so the import of this test in the NLRB setting is we're going to make less people contractors and more people employees. And I'm not going to read this whole thing to you, but you can see that particularly if you look at B, the worker performs work outside the usual course of the hiring entity's business, that is aimed, of course, toward people in the gig economy. Providing rides is Uber's business. And so if you're a driver for Uber, you're an employee now because you're doing work that is within the usual course of the hiring entity's business. And it's very clear. And they tried this in California, and even in California, there was an uproar and a change in the law back to a way that allowed people to work in the gig economy that didn't dissuade this administration from attempting this. And so this is one thing that's in this law that's proposed that would allow more people to have employee status, which means that more people would have the option, the ability to organize and to join a union.
And Howard, so we're just going to note for the audience of if we were to rate the top 3-4 points for their consideration during the context of this presentation, the independent contractor and joint employer analysis changes are in that short list. You agree?
Yeah, they're big. They're big. I don't know if they're top 3, but they're top 5 because I got a couple other things coming up here that are really genuinely game changers. But this is certainly very big for all sorts of reasons outside this context, as you noted, Fred.
Yeah, let's go ahead to micro units so that we can stay on task here because we're going to run out of
Okay.
time.
All right. We got to mention this one. Traditionally, what employers do is when the campaign is going on, the employer gets out their message by having, in many ways, but one of which, most common of which, for decades, is to have meetings where you have your representative talk to employees about your position, about how you believe things should go, why you don't want a union there. Often there are videos and things. This law would say you can't require anybody to attend such meetings. And so that's a way of saying, we're going to try to make employers fight with one hand behind their back. That'd be a very big change. We can manage around it, but it's really, really big. I'll skip a few of these things, keep us going. Now, unions can petition for micro units. What that means is, in a nutshell, one of the questions in an election is the group of employees that the union petitions to represent appropriate? And for years and years, if you went into let's say a production plant, and you said, and they have assemblers and machine operators, and they have welders, and they have 4 or 5 categories of employees, all of whom are engaged in the production process. If the union said, okay, we're going to petition to represent the welders, that's all we want. Well, the employer would say, no, you have to. All of these production employees, production and maintenance, share a community of interest, and you're going to have to. You can't just cherry pick one group among them. And in the past, they couldn't. And what this law does, and rather quickly, is say, well, a union could represent the welders and only the welders. And so if you have a discontented group, a group of prima donnas in one area, one department of your workforce, they could end up letting the union get their camel's nose under the tent, if you will, in a way that just simply would not have been allowed in the past. And so that's another change. It makes it easier designed to make it easier for, and would make it easier for a union to get their foot in the door.
Hey, Howard, one other, before you go on
Sure.
to the next point, on your prior point about email, obviously I am assuming your guidance to the audience is that, regardless of whether or not this law changes such that a union can use their company's email to organize, if you don't have a proper policy in place about who can use company email and for what purposes they can and cannot use company email, and you actually enforce that policy, you are setting yourself up for failure, even potentially without a change in the law.
Yep, this is true. You want your policy in order and you want your enforcement in order, regardless of what happens here. Okay, I'm trying to get where okay. I'm going to go over these rather quickly because the next 4 or 5 slides make a point about how this law would make it easier for the people to vote and quicker for a vote to take place. And so you can see here the union may conduct an election by certified mail. They can do it off-site. Commonly in the past, the way they conducted them was people showed up at the workplace in a conference room or something and voted. So they're trying to make it easier there. Pre-election hearing, no later than 8 days after the notice of hearing. 2 days after that, you have to post a notice of the petition for the election. The election has to be scheduled for the earliest date practicable, but not later than the 20th business day after the election is directed. In other words, we're pretty much back to quickie elections. So you're going to be, if the union files a petition, the employer is going to be required to do a number of administrative things quickly, and is also going to have a much shorter period of time in which to campaign and get its message out, and is now being told you can't have mandatory meetings in order to get your message out. So all those things work together to create an environment where elections are going to be held in a manner that is more favorable to unions and less favorable to employers. Well, suppose you get through the election and heaven forbid you lost, and now you have to engage in bargaining. You have to sit down and try to get an agreement. It looks a lot more like this these days. If you're the employer, if this law were to pass, if you're bargaining for the initial collective bargaining agreement, it's the new election, you don't have an agreement in place, you haven't had the union there before, then you have to begin bargaining within 10 days after a written request or at a later date if the parties agree. But you can't, if you try to put it off and the other side doesn't agree, now you're going to be in violation of the law. If no contract is reached within 90 days, either party may request Federal Mediation and Conciliation Service assistance. Now, the FMCS has been around for a long time. If you're having a difficult time in your negotiation, they will send somebody in to try to help both sides. That's been the case. They can be very helpful if you're having a tough time of it. But this puts a time limit on it. If you don't have a contract in 90 days, either one of you can request FMCS assistance. Once FMCS comes in, if there's no agreement after 30 days or longer, if the parties agree, FMCS will refer to arbitration. Now, this is where you have a huge change. I mean, in the past, there were times, particularly if employers felt that the union majority was very tenuous, you could bargain for a while and keep it going. And I've even been involved in situations where the parties bargained for more than a year, and then you got a decertification petition in from employees that weren't happy, and you ended up being able to get the union out of the scene. That's not going to happen here. Once it gets referred to arbitration, the union and the employer will select one arbitrator each and jointly select a third. You got 14 days to do that. FMCS has panels, which we use in grievance arbitrations and such these days already. So they have panels in place. Then you have an arbitration panel that hears each side's presentation. And at the end of that, this arbitration panel imposes an agreement that is effective for 2 years. So this panel will look at, what's your size, what's your financial status, what's the cost of living in the area, what are the typical industry wages and benefits. So look at all those things. You can put whatever information in front of them that you like. But at the end of the day, if the parties do not agree, this panel will set your employees' wages and benefits for 2 years. That is a huge sea change in how this is done. It gives third parties who may or may not know anything about your business the opportunity and the power to tell you what you're going to pay and what your benefits are going to be for a 2-year period. Now, you can, at the end of that 2 years, you're back in bargaining again, and at least as the law is written now, there's not a similar provision for bargaining over a renewal of a collective bargaining agreement. these rules apply to when the parties are trying to reach an initial collective bargaining agreement. But nevertheless, it absolutely puts the power in the hand of a third party, three third parties, the arbitration panel, to decide what your pay is going to be and what your benefits are going to be for the employees that are in the bargaining unit and represented.
Howard,
And so,
let's talk about what you say it's a sea change, but some of our audience may not fully understand why this is such a sea change and why it's so significant. Compare it to how things would have been done previously.
well, how things would have been done previously is assuming that a union wins an election, the bargaining obligation attaches, it's there. And so the employer was required and has always been required to bargain in good faith with the union towards reaching an agreement if a union is selected and certified as an employee representative. So that's not new. But in the past, as long as you were going along and bargaining and trying to get an agreement, if it took 3 months, if it took 8 months, if it took a year and a half, whatever it took, as long as somebody didn't get caught in bad faith bargaining, and even then, the order tended to be, now you got to bargain in good faith, because the labor board would not and could not set your terms and conditions of employment. There had to ultimately be some kind of an agreement between the parties to settle that. And the weapons, if you will, that pushed to agreement, if necessary, were that an employer could engage in a lockout of employees, or employees could go on strike. And each side had its economic weaponry, if you will, if they chose to use it. You don't have a whole lot of strikes or lockouts anymore, but those things were there. They were in place. And there was no set of circumstances under which the third party was going to just simply set your agreement for you. One way or the other, the parties would have to come to some sort of an agreement. And that is the way it was from the 1940s until now. It's still that way now. This law would change that.
Yeah. So
this
Howard,
law would,
I'm sorry, go ahead, finish your thought.
well, this law would change that. It would give outsiders the absolute power to write your agreement for you if you don't reach one.
So last year and this year, you and I have worked together on a couple of scenarios with employers who are negotiating contracts
Right.
with the UAW, and so one of the experiences that we've had, and obviously that's one union, and not every union has the same philosophy about how they're going to conduct business. But one of the things that I've noted in these negotiations has been that if there are issues where both sides agree there's an issue that needs to be grappled with and agreed upon, but we're not going to be able to do it in a prescribed time frame, that there is discussion about, okay, well, can we continue this current contract for another 90 days to give us time to work through things, such that there's discretion exercised by both parties to try and continue to work and negotiate in good faith to come to some resolution. And that also seems to short circuit issues like lockouts, strikes, generally helps avoid unfair labor practices. But now what you're telling us is that, not only is that discretion taken away from both sides, but it gives the union sort of this general, it's a weapon that, okay, we could theoretically drag our feet or not really cooperate a whole lot. And then we're just going to add some third party, who doesn't run a business, who isn't responsible for the decisions they make in terms of they impose a 2-year contract on you, and it sinks your business financially, right? They've got no skin in the game. I mean, is that what we're talking about?
Yeah, I mean, even under this law, if the time frames can vary, but it says if both sides agree. And this is for an initial contract only. So not when you're bargaining for renewal, but yes, in the initial bargaining for an initial contract between the employer and the union, if the union just decided, we don't think these people are interested in paying us what we believe they should, they have the absolute ability within these time frames to push this to arbitration get an arbitration and have those folks set the wages and benefits. And that is an absolutely new power that no one has ever had before.
Yeah. So for the audience, I mean, when Howard says this is a sea change, it's literally a sea change. I mean, just think about that for a second, that how wages and benefits for a 2-year period are set as to a certain group of your employee base, that you have no say in it, essentially. And Howard, what happens if the employer says, you know what, this is absurd. We disagree with this FCMS decision. What are their appeal options?
There's nothing in this law that gives them one.
They're stuck with it.
Yep.
Okay.
Yeah. I mean, this is, this to me, you said, what are one of the 2 or 3 things to remember? This is in the top 3. Because
Okay.
if this actually becomes law, employers will have wages and benefits imposed on them by third parties out who may or may not know anything about their business, and certainly will, as you have put it, have no skin in the game. When they make a decision and issue it, they're done. And there's no consequences to them regardless of how it goes.
Yeah.
It's really out there that they would do this, but it's a key aspect of this law, I think, in the Democrats' view.
All right. Well,
the supporters of view of it.
I think we're on to enforcement, and then let's go ahead and get to some of these issues.
Yep. So I'll run through these a little more quicker to try to keep us on schedule as best we can. But this gives back pay with no reduction for interim earnings. So how they're going to figure that is hard to say, because when does it end? But when does the back pay period end? Because the person now has another job. I guess they're going to count it from until the decision is made that the employee was discriminated against. And have front pay. So I was making $20 an hour for you, and I got another job, but now I'm only making 18. Well, for some period of time, even after I go to that new job, I'll get a differential. I'll get an award for $2 an hour differential for some period of time to be decided by a law judge. Consequential damages, which is not something that was even mentioned before. Liquidated damages equal to 2 times the damage award. That's totally new. So if you get an award for $20,000 in lost back pay, well, now it's 40. I mean, now it's actually 2 times the damage award. So now it's 60 that they get. So it's just a punishment. And these remedies apply equally to unauthorized aliens. So you can be here illegally, file a charge with the labor board, get your back pay, get liquidated damages of 2 times the back pay. Not reduced by any interim earnings that you may have. So that was way, way bigger than what we had before. Now you got penalties: failure to comply with the board order, the civil penalty of up to $10,000. Each day is a separate offense. Nothing like this was in the law before. An employer that commits a ULP and unfair labor practice in violation of Section 8 of the Act, and we'll let you know all the things in Section 8 in just a minute, shall, in addition to any remedy ordered, so in addition to whatever you got to pay the employee, there can be a civil penalty of up to $50,000. If the unfair labor practice resulted in discharge or other serious economic harm, whatever that means, to the employee, the penalty is doubled if the employer has committed previous such violations in the last 5 years. So if you were found to have discharged an employee in violation of the National Labor Relations Act 2 years ago, and then something happens and you discharge somebody for calling their manager a name, as Fred mentioned, and the labor board brings a claim and decides that was unlawful, now you got a double, in addition to what you pay the employee, now you got a double penalty because it's within 5 years. Again, nothing whatsoever like that in the previous law and previous history of this law.
Howard, if we're doing the math on that, so if it was 20,000 in back wages and you got the double damages, so you got another 40 tacked on at 60, is that saying what you just read? Does that mean that now, if because it's a repeat offense, kind of like under the OSHA analysis, a repeat citation for the same violation of the same standard, we're talking goes from 60 to 120?
No, that would still be 60, but on top of the 60, that's what the employee gets. On top of that, then you got this civil penalty of up to $50,000. So you could have the 60 that the employee gets, and then another 50 on top of that. And then if you do it again within 5 years, instead of another 50, you could be looking at another 100
So the
in a
50
civil
is
penalty.
what could double.
Yeah.
Right.
Yep. Again, this is totally new. So, okay, so if you commit an unfair labor practice in violation of Section 8, what's in Section 8? Threat. A threat doesn't usually result in economic harm much. Company-dominated union, you're not likely to see much there. What you're really looking at mostly is 8.3, discrimination for union activity or sympathy. That is where that is the section of the law that claims are filed under when an employer allegedly discharges somebody for their union sympathies or activities. Also under 8.4, discrimination based on having filed a charge with the labor board or given testimony in a board proceeding. That's a sort of a retaliation type provision. So if you fire somebody and you're found to have done so in violation of either 8.3 or 8.4, that's when those liquidated damages and then civil penalties are going to come into play.
Howard, we have a question. Let me just
Sure.
ask the question from David Sullivan. How does this compare to the neutrality agreements in 1997, i.e. Johnson Controls v. UAW?
And this law that I, having read through it, didn't really address neutrality agreements. Neutrality agreement is where an employer reaches an agreement with the union fundamentally that says, if you want to come in and try and organize our people, we're not going to take a position. We're not going to tell them that they should or shouldn't join a union. We're going to be neutral, is what it sounds like. And of course, if you entered a neutrality agreement and followed it, then you're not going to violate these provisions and face these kind of remedies. But if you decide that you want to fight the organizing, then these are the kind of risks that this law would impose on you as an employer. Okay. Another new provision under remedies is that if the board decides that director and officer liability should be imposed, there may be a civil penalty against the director or officer who either committed the violation or established a policy that led to the violation or had knowledge of what was going on and failed to prevent it. And this is a pretty loose standard. It's like if the board decides. Well, how are they going to decide that? We don't really know. But if they do, they're going to have the ability to impose civil penalties on directors and officers individually who they decide have engaged in activities themselves in violation of National Labor Relations Act, in particular for Section 8A violations.
Has this ever existed before?
Nope, totally new again.
Right, so individual liability.
Yep, individual liability. I mean, these changes obviously are designed to try and make employers more risk averse to aggressively managing their business, holding their employees accountable for their actions or for doing anything that might even plausibly be seen to violate this law. Because if you're found to do so, the penalties become way more draconian than they have ever been in the past. Here's another aspect of that. Person injured by a violation of 8.1 or 3, remember that's where you discharge somebody for their union sympathies or activities. They can still file a charge with the labor board, but if it's still sitting there within 150 days, they can go ahead and get out of there and go to court. Or if the board says, we really don't see anything here, we don't think you were discriminated against, and they tell the employee, we're not going to chase this ourselves. And so the employee can then on their own go out and file a lawsuit in court and sue you. And that has never been the case under this act before. And before, if an employee filed a charge and said, hey, or a union on their behalf and said, I think I was discharged for my campaigning on behalf of the union or filing grievances on behalf of the union, whatever it may be, the labor board will investigate. And if they decide that, there's really nothing here, we don't think that happened, and so we're not going to proceed, the employee could, if the regional director made that decision, the employee could appeal it to Washington, and very rarely would that ever be changed. But they did not have an option of then going out on their own and pursuing a lawsuit. But under this law, they would. So it would give employees the ability to continue to chase you and sue you, even if the labor board themselves decided that we don't really see anything here. If the employee does this and files a lawsuit of this nature, they can get punitive damages, again, never available before. They can get any other relief authorized under Title VII, which is the general discrimination laws. So it gives them everything there. They can get attorney's fees. So employees under this law now have the right to come after you on their own, even if the labor board doesn't see anything there, and can obtain all of these damages that we've described. And
before you go on, the attorney's fees, though, as for most of the people out here, if you haven't been involved in this type of litigation, either under the FLSA or under Title VII, the attorney's fees most times become the 500-pound gorilla in the room in the vast majority of cases. It's not necessarily how much liability exposure is, especially if there's discussion about resolution, it's the attorney's fees. So adding attorney's fees to this type of a statute is a huge, huge stick that can be used against employers.
It is, for sure. Here's another category where that gets added. There's a whole section here of this law under whistleblower protections, which says if you're an applicant, an employee, a former employee, and including management employees, which is also new, they're all protected. The employer cannot terminate or discriminate against employees based on if they provide information to a labor organization, to the Department of Labor, any other state or local government authority regarding an action that the employee reasonably believes violates the National Labor Relations Act. So this is a applicants, employees, management employees, a whole category of folks who can be described as whistleblowers if they provide information about what they think to be a violation of the act, and they subsequently are let go or discriminated against, or for testifying under the act, filing a proceeding under the act. They have a lawsuit now that they can bring against you, where they can file a complaint with the Secretary of Labor. They show that their protected activity was a contributing factor in the discriminatory decision. And if the employee establishes that, the employer has to prove same decision by clear and convincing evidence. So the burden of proof comes over to us as long as they can show contributing factor. Available relief under that law, action to abate the violation, reinstatement plus loss compensation, as well as compensatory damages, expungement of records. They can make you change your records. Costs, including attorney's fees. So there's the attorney's fees again that goes in. The Secretary does not issue a final order within 270 days or within 90 days after a written determination. The employee can go request de novo review in a U.S. District Court. So you go to the Secretary of Labor first, and the Secretary can seek all of those remedies that we just went through for the employee. And then if the employee doesn't like what happened there, the employee can just go to court. And when you say de novo review, what that means is they can get a jury trial after you could have gone through this for 6 months with the Secretary of Labor, gone through the investigation, had witness interviews, the whole 9 yards, and the employee just goes, well, I don't like what they're doing, so I'm going to go to court. And now you're going to have to go through all that. So it creates a huge burden if you get into one of these whistleblower protection actions, and with lots of potentially very tough consequences for the employer. So, we've buzzed through that relatively fast.
Howard, let me jump in because there's something I want to, we've got about 9
Please.
minutes left, but there's something I
Okay.
wanted to mention. For those of you who have heard me speak about the EEOC, and especially, when I show my graphs on statistics, you see that in the last 10 years, the number one most commonly filed charge with the EEOC has been retaliation. And it's not underlying harassment or discrimination cases, it's retaliation far and away. What
Yes.
some of the import of having this whistleblower statute there, which is a form of retaliation, being a whistleblower and a claim is a form of retaliation, is that it is such an easy trap to
Yep.
fall into. Even if the claim doesn't have merit, you still have to defend it. And even if you win, by the time you defend dealing with it at the administrative level, and then you have to segue into litigation, the amount of time and money you could spend is going to be cost prohibitive. In other words, you're going to be almost forced to come to some resolution that you may or may not like and want to live with, because the alternative, just in terms of the cost of fighting it, is so significant. So I wanted to make that point, Howard.
And that's exactly the point, I think, that of this whole enforcement and remedy provisions under this law is they're wanting to send the message to employers, step carefully and try to discourage employers from making decisions that could lead to these kind of claims, which of course just kind of can change the culture and the atmosphere that we're dealing in, and will give employees much more ability to create a lot of pain for you, just simply in the hassle of having to deal with all these different kinds of claims. The hassle and the expense of it, and as if you've been through much in the way of lawsuits, you know already that the expenses, attorney's fees are one thing, but the real sort of cost, the big cost in many cases, is simply the amount of management time that an employer has to put into preparing to defend itself and going through the process. And so it's the message here, the import here is we want you to step carefully. We want you to be more risk averse when you're dealing with employees, because they're going to have much more ability under these rules to make your life more miserable.
Howard, we've got about 6 minutes left. So let's hit for about 4 minutes. Let's hit some other takeaways. In the last 2 minutes, I want you to help the audience understand the top 3 or 4 pitfalls that you see in this, so we can kind of circle back to that original point and wrap it up.
Sure. Joint employment, Fred mentioned, is similar to independent contractor. The boards have gone back and forth on this, and the Trump board enacted regulations on this subject. This is now trying to sort of go a step beyond that and put it in the statute itself and say that indirect control can be sufficient to establish a joint employment, even if it's not exercised so much. So again, they're trying to give the union the ability to have 2 employers on the hook. Employers can no longer permanently replace economic strikers. It's been the law for a long time under the labor board that if someone is an economic striker, not an unfair labor practice striker, they can be permanently replaced. This law takes that away. This law says an employer may not lock out employees to influence them or the union in collective bargaining prior to getting an agreement or prior to a strike. So you don't have the lockout tool to enforce your position in collective bargaining. So it takes away an economic tool of the employer cannot require employees to sign an agreement preventing them from bringing or joining a class action lawsuit unless reached via collective bargaining agreement. And of course, no union is going to agree to that. So would make it a federal law that you cannot have a class action waiver with your employees. It permits fair share agreements, notwithstanding right to work laws. And a fair share agreement is where an employee can be employees represented by a union. They're not going to be compelled to join the union in right to work states, but they are going to be compelled to pay the union what's an amount that is determined to be a fair share in compensation for the union's activities in representing the employees, negotiating for collective bargaining, filing and presenting grievances, those types of things that are direct representation. So it doesn't exactly overturn right to work laws as it has been reported in some ways. It's not that, but it does say that even if there is a right to work law, you can't be compelled to join, but you can be compelled to pay a percentage of the union dues. Another one is the persuader rule be revised such that attorneys and consultants who provide assistance during campaigns will be found to be persuaders. And if you're a persuader, then you have to file, you and the entity that employs you, uses your services, have to file reports with the Department of Labor that say, describe what you've done, how much you were paid for it, how much was spent on it. And so for many years, attorneys and certain consultants who assisted employers in campaigns and other activities were not considered persuaders. You're providing legal advice. So the American Bar Association opposed this rule when it was proposed again a few years earlier, and will oppose it now. One of the unintended consequences of this could be, however, that now attorneys and people who do what we do might as well go ahead and just take a much more active role in campaigns and have had a good track record of success in helping employers do that years ago, which ironically was one of the reasons the persuader rule was put in the first place. So this could actually turn out to be something that makes it harder for unions to organize and gives employers a strength that they didn't previously have. But we'll see whether it stays in. I have some doubts.
All right. So Howard, we got 2 minutes. Let's wrap up. Besides obviously opposing passage of the law, currently as it's written, we know the Senate's 50-50 with the vice president having a deciding vote, but whether or not, there are going to be 50 Democrats that sign on to this in the Senate is to be determined. I think there's going to be vigorous opposition. It could be that there's some compromise reached. I have no idea. But let's assume that in a worst case scenario, the law this bill is passed in the Senate and signed by President Biden into law. What are the top 3-4 takeaways for our audience before we wrap up?
I think first of all, you've got to be very intentional about knowing what's going on in your workforce, because it can be easy to have discontentment in a particular area. And it's so much easier under this law for that to spin up into something that turns into now you have a union in place. So you got to be more aware. You got to be very aware. I think secondly, if this becomes law or something much like it, that you'll want to be more open with your workforce on a more regular basis about your opposition to having a union come in. You're going to have to engage in the right way, crafting the message to your employees, because the best thing you can do is be preventive on the front end rather than find yourself in the middle of a mess, and that's when you're more likely to mess up, to goof up and violate some of these things anyway, is when you're having to rush around because you've been caught off guard. So the biggest thing is you got to know your people, your workforce, be intentional about doing it, learning what's going on, train your management team, engage your HR team, and be preventive, because that is the absolute best way to stay out of this mess and to not run afoul of any of these laws, is to have your workforce managed on the front end such that it never just blows up and becomes an issue.
So in other words, pay attention to the little issues, because if you don't pay attention to the little issues, they become big issues.
Big issues that can bite you much harder than they could have bit you in the past.
All right, guys, we're right at 3 o'clock, so we're going to stop. If you have questions, obviously you can follow up with us. Susie, I'm assuming you're going to have a survey or something where people can also communicate with you if they have thoughts, comments, questions. We appreciate the time. We hope that this has been helpful. And like I said, if any of you have questions, hit us up offline.